If Meghan Markle and Prince Harry sat down across from me in Louisiana, the royal title wouldn't be the interesting part. What would actually keep me up at night, two kids who are dual citizens, a business that just lost its biggest investor, a charity that just restructured to bring those kids into the family mission, and property in 3 different countries. I'm Val, a Louisiana estate planning attorney, and this is the T, Trust Estates Assets. Combined, Meghan and Harry are worth an estimated $60 million. Built on the Netflix deal, Archwell Productions, and As Ever, Meghan's lifestyle brand. Netflix recently pulled out as an investor in As Ever, so the brand is now running independently with a COO handling day-to-day operations. On the charity side, the Archwell Foundation just restructured into Archwell Philanthropies, and Meghan and Harry said they're explicitly bringing Archie and Lilibet, ages 7 and 5, into the family's philanthropic work. And then there's the real estate. Their Montecito home is worth close to $29 million. In 24, they also bought a vacation property in Portugal. Meghan's American, Harry's British, and the kids were born on 2 different continents. That's 3 countries minimum. My first questions would be, if something happens to both of you, who's actually running As Ever? And how do Archie and Lilibet get what they're owed from it without the business falling apart? And second, when you say the kids are growing up in the family philanthropy, do you want that to be a legal commitment, or is it just how things are done right now? Both kids are under 24, so if they were Louisiana residents, forced heirship would automatically apply. Archie and Lilibet are each guaranteed their forced portion, their share of the estate, no matter what a will says. But with a business like As Ever in the mix, you can't just cut a check for their share. That could force a sale or gut the company's cash just to satisfy what's owed to them. So the fix is separating the economic interest from the operational control. The kids' guaranteed share is satisfied through non-voting interests held in trust. Their owners on paper sharing in the growth, while voting control stays with whoever's actually running things. I see versions of this constantly. Picture a family construction company. One sibling's run it her whole life while her 2 brothers moved out of state for their careers. All 3 might own a piece of it, but only one of them is driving the truck and signing the contracts. It's the same principle, split the value from the control. Now, the philanthropy piece, restructuring a foundation and saying we're bringing the kids in, it's a lovely sentiment, but it's an organizational decision, not a legal one. Whoever's in charge later can change it. So if you actually want charitable giving to be part of your legacy, something the kids inherit a real role in, it needs to live inside your trust documents. A charitable trust does 2 things at once. It can reduce what's subject to estate tax, which matters more once you're near that $15 million per person or $30 million per couple federal exemption in 2026. And it gives your kids actual legal authority to carry the mission forward, not just a title at a nonprofit that can be reconstructed without them. And that Portugal property adds a little wrinkle. Portugal is also a civil law country with its own version of forced heirship. Property there could trigger a guaranteed share for the children under Portuguese law, separate from whatever U.S. documents have to say. Louisiana isn't the odd one out here. It's part of the same legal tradition as a huge part of the rest of the world. It's the U.S. that's the exception. I have clients who own a piece of the family business without running it. Clients with land in another state or a place they bought out of the country for retirement. Clients who've talked about leaving something to a cause they care about but never put it in writing. Every one of these situations needs the same thing. It has to be in the documents, structured on purpose, not assumed. If Meghan Markle were my client, it wouldn't be about that $60 million number. It would be about making sure a business can survive a transition, a charitable mission has real legal teeth, and property in 3 countries doesn't end up working against itself. Good estate planning isn't just one document. It's making sure every piece, wherever it sits, is actually talking to all the other pieces. That's the T. Drop your thoughts below and follow for more.